Hi, my name's Ryan Heath, and I'm with Sarah Perna, and today we're going to talk about trust funding. Trust funding is an extremely important part of the estate planning process, and so glad to have Sarah here today, and we're going to give you some good information.
So just to kickstart things, can you briefly explain what it means to fund a trust?
Sure. So as part of the estate planning process, signing the documents is obviously step one, but step two is to fund the trust. Funding a trust is extremely important if you want to accomplish the primary objectives of setting up the trust in the first place, right? So probate avoidance, incapacity planning, consolidation of assets. And so funding a trust simply means changing the ownership of the assets from your individual name or names to the name of the trust.
Okay. And is it going to be the same process of funding for every asset, or does it vary?
It does vary a little bit depending on the type of asset. So I'll jump in and kind of cover the different types of assets most commonly put into a trust and how the funding process differs for those. So first, and kind of the one asset we typically think of first is our house. So once the trust is signed, your attorney will prepare a deed that transfers your home to the trust. And so it's just a 2-page or 3-page sheet of paper. It's signed, and then that deed is filed in the property records in the county where the property is located. At that point, the transfer itself is complete and the trust is the owner. But there are two important follow-up steps once that process is done. So first, since the home is owned by the trust, we also need to have the homeowner's policy list the trust as an insured on the policy. What that really deals with is if there's a claim for water damage, hail damage, something like that, if the trust is also named on the insurance policy, it will speed up the claims process. Secondly, once the home is transferred to the trust, the appraisal district, which is the taxing authority in Texas, will send out a homestead application form that needs to be filled out to keep the homestead property tax exemption in place.
And if I have a mortgage on my property, how is that going to impact things? Does it mess things up with my lender?
Well, it depends on the type of residence as to whether or not the lender needs to receive notice and approve the transfer. So for your primary residence, federal law protects that property and you can put it into the trust without any sort of hiccups whatsoever. In fact, with your primary residence, you don't even need to reach out to your lender. Just keep making payments as usual. For second homes or vacation properties, if you have a loan on those properties, it may be beneficial to reach out to the lender and ask for approval prior to transferring the property to the trust. Sometimes with these secondary properties, there can be penalties or an acceleration of your mortgage. And so getting approval on the front end is always the most prudent measure. And if the bank won't approve the transfer, we can always wait until the property's paid off and then do the transfer at that time.
Okay. And in the future, if I ever wanted to sell my house, how would having it in a trust impact that?
Really, nothing changes at all about the selling process. The only difference is that when the real estate contract is signed, the trust is going to be the seller of the property, not you in your personal name.
And in another category, what about banks and brokerage accounts?
Great question, Sarah. So for banks and brokerage accounts, we want to change the owner of the accounts. And when I say owner, what I mean is the titled owner. So if you log into your bank accounts on the computer or you get a bank statement in the mail, we want to change the account from Sarah Perna to the name of the living trust, right? And so there's several steps that we have to take after signing the trust to get the accounts retitled. So first is that you'll want to bring a copy of your trust or a trust summary to your bank or brokerage contact. Secondly, the bank contact will often ask for a tax ID number or an EIN for the trust. Since the trust is a revocable trust, it doesn't have a separate tax ID number or EIN, so you'll just put down your social security number in that blank. Sarah, most banks will be able to finish this process without changing bank account numbers. And that's really important for a lot of our clients. They have auto payments, auto drafts set up. And so we want to make sure that we can facilitate the change of account owner without changing the account number. So again, this may take several visits to your local bank in order to get the process done correctly. But if for some reason a bank just simply refuses to change the title on the account without changing the account number, reach out to your attorney. They can provide some alternative arrangements that will still avoid probate, protect against incapacity, but work around the issue with your local bank.
So another category I want to ask about is life insurance, annuities, and retirement accounts. How does that work?
Yeah, so life insurance, annuities, retirement plans, they're all a little bit different in nature than bank accounts, brokerage accounts, and real estate because these sorts of assets, again, life insurance, annuities, and retirement plans, they have beneficiary designations. And so when we're talking about funding the trust, here the owner of those sorts of plans won't change. But what we will change are the beneficiary designations on those types of assets. So for life insurance, the primary beneficiary may be spouse if you're married, and the contingent beneficiary may be the trust. Same is true for an annuity or for a retirement plan. In particular, with retirement plans, there are tax benefits to having your spouse named as primary beneficiary. But for single individuals, they may choose to name the trust as the primary beneficiary of the life insurance policy, the retirement plan, or the annuity. And so by reaching out to an attorney, they'll be able to help them navigate the proper beneficiary designations for those types of assets.
The last asset I want to mention is vehicles. Do those go into the trust too?
Generally, we don't put vehicles into a trust, and there are several reasons for that, right? Obviously, we change vehicles multiple times throughout our life, but there are two specific estate planning reasons why we don't put vehicles in trust. First is that in the event you pass away, there's a very simple process of getting title to a vehicle transferred down to a spouse or to children. And so that makes it really easy. There's no probate process. And so that's one reason. The second reason is that if we have the trust as the owner of the vehicle, then the automobile insurance policy also has to be in the name of the trust. So if we get an offender bender, someone asks for our insurance card and they see the trust as the owner, they end up suing us because they think we're billionaires. And so that's a second important reason from an asset protection standpoint that we don't put vehicles into a trust.
Okay, so once our trust is funded with the assets that go into it, what else is important to keep in mind?
Sure. So first, keep in mind, as I said earlier, that nothing's going to change about your everyday lives. You're going to put money in accounts, take money out, all the same way you do right now. Secondly, it's really important to remember that once you create this trust, you no longer open new bank accounts or purchase property in your personal name. So going forward, once the trust is created, if you buy real estate, then the trust should be the purchaser. If you open a new bank account, the bank account should be the owner of the account. If you purchase a new life insurance policy or an annuity contract or change jobs and have a new 401k, in all those scenarios, we want to have the trust named as the appropriate party, whether it's an owner or beneficiary designation on the front end, so that we can achieve the overall objectives of the trust, which again, trying to avoid probate, protecting against incapacity, and also making sure that we consolidate all of our assets into one place.
Absolutely. That's really practical information, Ryan. What about any last comments or suggestions that you might have?
Sure. So when hiring an estate planning attorney, it's really important to ask the attorney what all is covered as part of the estate planning project. So some attorneys will do a flat fee, some charge hourly, but asking about the scope of the funding work, how much will the attorney be involved in the process, that can change dramatically from firm to firm. And so just ask those questions on the front end so you will know what to expect. And with that, we've covered all we wanted to cover on trust funding in Texas. Thank you.